What are chemically contaminated zones? What is India's first law to clean up such zones? And what is government's big plan when we are talking about clean future for such toxic lands? Do you know that we have known for a decade that there are more than 100 contaminated sites where we have polluted water, polluted soil and probably polluted air as well. But only 7 of them have been remediated. And finally, the government has decided to take responsibility for the cleaner future with the Environmental Protection Management for Contaminated Lands Rules 2025. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand India's first legal framework which is going to help clear up, bring a clean future for toxic lands. Let us start by understanding these new rules which have been brought in for chemically contaminated sites. So when we talk about these rules, the biggest significance here is कि ये ऐसा पहली बार हुआ है कि हमारे पास एक proper legal framework है in our country, that it is the first time that we have a proper legal framework in our country that we can not just identify but also understand, assess and remediate sites जो कि polluted हैं by hazardous chemicals. So that means the sites which have been polluted by hazardous chemicals, they have been not just found out but also assessed, and remediation is also guaranteed or in process by these new rules. Now the question is, why was this needed in a country where we are surrounded by multiple problems? Why are we coming for a legal framework for this? Because as of now and for almost a decade, as I started with these lines, we have known that we have almost 100 plus sites. There can be more, but as per the data, we have known that there have been 100 plus sites. But you know what? Only remediation on 7 has begun and it has been working. Furthermore, in India, if we talk about chemically contaminated lands, there has been no proper mechanism for enforcement of the rules. There is no legally binding framework, as well as mismanagement or absence of timelines as well. So there was the need to bring in a proper framework which has enforcement mechanism, which has a timeline, and it can also assure that not only a fraction but all the chemically contaminated sites, lands or zones are addressed properly. Before I get into the details of the rules, यहाँ पे बहुत ज़रूरी हो जाता है कि हम समझ लें कि chemically contaminated land जो है हम उस किस चीज़ को बोल रहे हैं, आखिर क्या है chemically contaminated land. So basically अगर हम chemically contaminated site या land की बात कर रहे हैं तो ये कोई भी location हो सकता है. It can be any location जहाँ पर हमने historical dumping देखी है या फिर हमने वहाँ पे presence of hazardous waste देखा है. That means any specific location where you find historical dumping, not just for a year or two, where you have been seeing dumping for years, probably decades, and it has accumulated a lot of hazardous waste. Common examples that we have with us are old industrial estates, landfills and waste storage sites. And this leads to multiple problems such as pollution of the soil, the pollution of the water. Then we also have risks to human health as well as ecosystem. If we go to the data given by CPCB, that is Central Pollution Control Board, as I mentioned, there are 103 sites across India and there is severe extreme contamination in many. But when we talk about these new rules, they come as a ray of hope that there is a possibility for cleaner future in these toxic chemically contaminated lands. And if we talk about origin of these rules, if we try to understand the origin of these rules, this is not new. This had been part of 2010 capacity building program and this was for only industrial pollution management project. It was in this project that the inventory was created that how many chemically contaminated sites exist. Technical guide was also prepared and legal framework was not present. Legal framework was absent. Now which has been completed with these new rules. Environmental protection, where we are talking about management of contaminated land rules 2025. We will understand the significance of this particular rules only when we know the provisions. So let us start with understanding the key features of this new rule that lies in front of us. So the first one is identification and reporting. That means there will be proper inventory creation. Districts will properly report any suspected contamination sites, and it will be done every 6 months, and that will be going to SPCB, that is State Pollution Control Board. Then we have assessment and survey. When we talk about assessment and survey, in this we will be focusing on preliminary assessment, which will happen within 90 days as soon as there has been identification, and after that there will be a detailed site survey in case we find that there is some kind of contamination, if we suspect there is some kind of contamination. After that there is mention of remediation as well. So remediation planning will be done by experts. एक्सपर्ट्स जो होंगे वो रेकमेंड करेंगे कि क्लीन अप प्लान क्या होगा, और साथ ही साथ यहाँ पे एसपीसीबी जो है वो फोकस कर रही है पोल्यूटर पेज प्रिंसिपल पे. दैट मीन्स एसपीसीबी इज फोकसिंग ऑन पोल्यूटर्स पे प्रिंसिपल, दैट इज दैट द पोल्यूटर्स वुड बी आइडेंटिफाइड एंड अकॉर्डिंगली दे विल बी very much part of the cleanup plan. Furthermore, the cost and liability, as I said, polluters will be the ones paying for the damage that they have done, and all of this has been given legal enforcement through that there will be criminal liability, which is covered in Bharatiya Nyaya Sanhita. So when we talk about the whole process, it has been clearly bifurcated into 3 parts. The first one is identification and reporting. This will be done by whom? This will be done by district administration, and they will be sending in reports every 6 months. Next party which is involved in here, it is the State Pollution Control Board, because these yearly reports will be received by State Pollution Control Board. The second part of these rules comes through assessment and survey. Now once the SPCB has received the report from the district administration, they are the ones who have to carry out preliminary assessment, and there is a proper timeline for that, that is 90 days. If there is any suspected contamination, there is a detailed survey that will take place again in a given timeline of next 3 months, and this is also specified which chemicals are to be tested, which chemicals are to be found. 189 hazardous chemicals. If this location is unsafe, then awareness will also be created. That means site, that particular location, उसको properly notify किया जाएगा और उसकी location को restrict किया जाएगा. And the third part comes with remediation and liability. How to repair that situation, how to repair that site, bring a cleaner future for it, and who pays for that plan. So that plan is to be paid by the polluter. That is polluter pays principle. Furthermore, if there is severe harm that is found, it is going to be a criminal liability as per Bharatiya Nyaya Sanhita BNS 2023. All of this has been covered in this rules, which makes it very much significant as compared to the earlier, or you can say half-baked steps that were taken in this very direction. Let us talk about the significance of this particular step. The first significance itself is the fact that it is not just the first legal framework, but it is also structured and enforceable to make sure there is space for remediation in India, and this is happening for the first time. Another significance that comes with it is the fact there is a strong focus on public health protection and also environmental recovery, which was lacking in previous projects and plans. But even after the significance that we are applauding these rules for, there are multiple gaps that we also need to understand, because there have been some exemptions that have been given in these rules. If we talk about exemptions, exemptions have been given to some hazardous chemicals such as radioactive waste. There has been exemption given to mining related contamination, marine oil spill. So you are trying to exclude economic activities associated contaminated sites, which will be a problem. Furthermore, municipal waste which is being dumped, solid waste which is being dumped, which is covered in other laws, has also been exempted. That means multiple chemically contaminated sites are being exempted through these rules, and this is a big gap that this legal enforcement framework has left behind. Another gap that needs to be understood is the fact that even though there has been a proper timeline and enforceability comes with it, there has been no fixed deadline which has been given for completion of remediation. There has been deadline for assessment, there has been deadline for survey, but completion of remediation, there has been no deadline, and this leaves it open to multiple challenges which it might recover through, which it might perform against, but there is also a possibility that these challenges might make these rules succumb as well. So I will leave you with a question: what do you think are the challenges, real challenges present in front of these rules, which need to be considered so as to make sure that this first legal framework, which is structured, which is enforceable for specially chemically contaminated zones, becomes successful? Now that was all from my side. Thank you so much.